Okay, well, thank you, Nick, and good morning, everyone. My name is Marty Rabinovitch, and this presentation is on the latest on termination clauses, and specifically we'll look at a 2018 Court of Appeal case called Amberber and IBM. But before we get there, let's do a little bit of background here. So, what is a termination clause, and why do employers like them? So in the context of an employment agreement, a termination clause sets out the employee's entitlements upon termination without cause with respect to notice, pay in lieu of notice, severance pay, and benefit continuation. Typically, termination clauses are drafted in favor of the employer, and they have become increasingly popular and common in employment agreements. Sometimes employees do like termination clauses as well because they do provide some level of certainty as to what the entitlement is going to be upon termination. But there is a bit of a balancing act there, right? An employee is not likely to want to trade certainty for giving up their entire common law entitlement and instead agreeing to only the statutory minimums that are set out in the Employment Standards Act. So why are termination clauses important? Well, the common law provides rights to employees with respect to the notice period, which are fairly lucrative to the employee, but at the expense of the employer. Termination clauses are normally drafted to limit what the employer must pay to an employee upon termination, and can also set a formula for calculating notice or actually stipulating what the notice period could be. So, for example, you could have a termination clause that says if the employee is terminated without cause, the employee is entitled to 2 weeks per completed year of service, or 3 weeks per completed year of service, or 3 weeks per year of service and a prorated amount for partial years of service. Okay? So to give you a sense of it, you could have a senior employee without a termination clause being entitled to a significant amount of common law notice. The unofficial cap is still around 24 months, although there have been some cases that we've seen where we're seeing notice periods, common law notice periods of 25, 26, 27, and there was even a fairly recent case where we had a common law notice period of 30 months. And in that case, the court actually said, well, and by the way, if the employee had asked for 36, I would have given it to you. Okay? These were very specific fact circumstances in that case, but I just raised that as sort of one example on the very, very high end. But we're still generally dealing with a common law notice period cap of about 24 months. But the point here being that without a termination clause, employers are going to get stuck with these high common law entitlements. Whereas with a termination clause, the employee's entitlement would be reduced. Okay? So very important is that for employers who are dealing with termination clauses, the employer and the employee cannot contract out of the Employment Standards Act. Okay, so the most that an employer can achieve by way of reducing the employee's entitlement would be to limit the employee's entitlement upon termination without cause to the statutory minimums that are set out in the Employment Standards Act. Otherwise, the clause will be found unenforceable, and guess what? Now we're stuck with the common law again. Okay? So this is an example of a sample termination clause that we like. Okay, there's a lot going on in the clause. I mean, so if you want to limit the employee's entitlement to the Employment Standards Act minimums, you need to reference things like the requirement to continue the employee's benefits, which is set out in the Employment Standards Act. Okay, we like to use the phrase payments and entitlements because what if we forgot something? What if the Employment Standards Act gets amended soon and there's a new entitlement? Okay, that would get caught in that language. Okay, and the second paragraph of this sample clause is essentially specifying that the minimum Employment Standards Act entitlements are not a floor of rights, but they're actually now the ceiling. Okay, and there are some cases that have held that without that statement, that the employee would be entitled to more beyond the Employment Standards Act minimums. Okay, quickly some of the pitfalls in drafting termination clauses. So the intent may very well be to limit the entitlement to the Employment Standards Act minimums, but the employer in the contract fails to mention a particular benefit, such as severance pay or benefit continuation. Another problem is if the clause, frankly, is just poorly drafted and the language is not clear and the court finds it to be ambiguous. And if it's ambiguous, the court is probably going to say, well, that the common law presumption was not displaced, so therefore this employee is entitled to common law. Okay, and thirdly, we sometimes see termination clauses that provide a formula for calculating the notice period, which may not comply with the ESA. So for example, if there's a termination clause that says, well, no matter what, if there's a termination without cause, the employee is entitled to 3 months of notice. All right? Well, if you terminate that employee after 1 year, well, sure, 3 months is going to exceed the Employment Standards Act minimums. But what if the employee works for 24 years and it's a big company? Okay? In that case, the minimum entitlement under employment standards legislation will be greater than 3 months. And there's a whole line of cases where the courts have said that sort of language is no good and will be struck out. Okay, so the termination clause has to comply with the ESA both at the present time and at future times too, in order to be enforceable. So there's been a lot of termination clause cases that have been decided over the years. Frankly, a lot of them are all over the place. The law in this regard is still, I would say, at the very least, somewhat uncertain. But we're going to briefly go through a couple of the more recent Court of Appeal cases, which hopefully will help in cleaning up this area of the law. So, Ward and Fred Dealey, that's a 27 Court of Appeal case. Not surprisingly, given the topic of the presentation, that this one involves a termination and a termination clause. So we have the termination clause here set out, okay? And it's there for you to read and to take a look at on your own if you'd like. But essentially, the problem that the Court of Appeal saw in this case was that the company listed a whole bunch of benefits in the termination clause and then said, well, this is everything. All you get is what is in this paragraph, except they forgot to include health and dental benefit continuation, right? So the court says, well, no, that's going to be unenforceable. Okay, so on this slide where we're looking at the Court of Appeal decision, the court says, well, it's not enforceable because the benefit plan contributions were not mentioned. And that is considered by the court to be an attempt on the part of parties to contract out of the Employment Standards Act minimums, which we cannot do. Okay? Then there was another 2017 Court of Appeal case called North and Metaswitch. And again, we have an employee who was terminated, and there was a termination clause in the contract. Okay, and this is the termination clause here. Okay, so this one I will read out. Okay, the company may terminate your employment at any time at its sole discretion for any reason without cause upon providing you with notice and severance if applicable in accordance with the provisions of the Ontario Employment Standards Act. In addition, the company will continue to pay its share of your employee benefits, if any, and only for that period required by the Act. In the event of the termination of your employment, any payments owing to you shall be based on your base salary as defined in this agreement. Well, we almost have it, okay? It was almost enforceable, okay? The problem is this last little paragraph about the base salary, because this employee was entitled to earn commissions, and commissions are defined, are included in the definition of wages in the Employment Standards Act. So now again, we have an attempt to contract out of the Employment Standards Act. The courts don't like that. whole clause is out, and now we're stuck with the common law again. Okay? And now more recently, in 2018, we get another Court of Appeal case. This one is called Amberber and IBM. Okay, so again, it's another employee terminated without cause. There's a termination clause. Okay, and here is the termination clause in question. Okay, I will read this one out, and you see that it's actually divided into 3 different colors, and you will see why very, very shortly. Okay, so the termination clause says, if you are terminated by IBM other than for cause, so really without cause, IBM will provide you with a notice or separation payment in lieu of notice of termination equal to the greater of A, 1 month of your current annual base salary, or B, 1 week of your current annual base salary for each completed 6 months worked from your IBM service reference date to a maximum of 12 months of your annual base salary. Okay, so that's the first part. Okay? Second part says, this payment includes any and all termination, notice pay, and severance payments you may be entitled to under provincial employment standards legislation and common law. Any separation payment will be subject to applicable statutory deductions. In addition, you will be entitled to benefit continuation for the minimum notice period under applicable provincial employment standards legislation. That's part 2. Now part 3, in the event the applicable provincial employment standard legislation provides you with a superior entitlement upon termination of employment than provided for in this offer of employment, IBM shall provide you with your statutory entitlements in substitution for your rights under this offer of employment. So pretty long, looks pretty complete, right? But at trial, basically what we get is we have a judge at the trial level that really dissects this clause part by part by part. So the trial judge looks at that termination clause and says, okay, well, I think it consists of 3 parts. The options provision, which was the first part there, the inclusive payment provision, which was the second, and what the judge called the fail-safe provision at the end. So the judge decides that it was clear that the inclusive payment provision applied to the options provision, so the first part, but it was not clear that the inclusive payment provision was meant to apply to the fail-safe provision because the inclusive payment provision was not again repeated after the fail-safe provision. Okay? So basically what the trial judge said, just to go back, is the blue section here was not repeated, at the end. So now this is causing an ambiguity, and I'm now not going to enforce this clause. Okay? This makes its way up to the Court of Appeal, and the Court of Appeal says, no. Enough of this. Okay? It is not the job of the courts to start dissecting these clauses with a fine-tooth comb and trying to find these ambiguities where there aren't any. Okay? The whole reason why the judges or the courts, in my view, started making these termination clauses very, very, very difficult to be held enforceable was really for a policy reason. And that policy reason was that courts just did not like, on principle, these very limiting termination clauses that were really significantly limiting the amounts of severance that employees were getting. So in my view, the courts were essentially looking for a way around these clauses to help employees. Okay? And that's where we got all sorts of conflicting decisions out there. But the Court of Appeal in Amberber says, no. The trial judge should not have been subdividing this termination clauses into 3 parts and saying, well, it's not enforceable because one part was not repeated at the end. No. Let's read the clause. Let's consider what it means in plain English. And when you do that, it's actually very clear what the employer is trying to do. They're trying to say, this is your entitlement. If the ESA gives you more, we're going to comply with the ESA. There's an intent to comply with the ESA, okay? And we're not going to go find these ambiguities in termination clauses where they simply don't exist. Okay, so Again, this area of the law is still somewhat uncertain, but I would say that this one is a win for employers. Okay? Doesn't necessarily mean that you shouldn't be careful when you're drafting clauses, but I would chalk this one up as a win for employers. Okay, so in terms of the takeaways from this case, yes, it is good news. We now have a recent Court of Appeal case which should help out employers who may be stuck with a termination clause that was drafted several years ago, which may be somewhat ambiguous. Okay? Number two, decision makers need to consider the entire termination clause and avoid reaching decisions based on parts of the clause. The decision makers are not to strain to create these ambiguities that don't really exist. Okay, but that being said, there's all sorts of Court of Appeal decisions out there. Okay, there is in fact at least one that I can think of right now that doesn't really adopt a lot of this same reasoning. So there still is a level of uncertainty. So if you as an employer are looking to add a termination clause to your employment contracts or modify the one that you have, I would still say that it's very important to get legal advice about that. And one final option that I'll just throw out there before I end is that if you really don't want to go through this whole potential uncertainty and potentially end up getting sued by an employee over the enforceability of an ESA termination clause, what you might consider doing is, if you want to have a termination clause, agree on an amount with the employee that is greater than their ESA entitlements but less than what you would expect them to be entitled to in common law. Because then you don't get into a problem of being accused of contracting out of the ESA, because that is the starting point for all of these cases. We can't contract out of the ESA. But if you're prepared to give your employees a greater entitlement than what's in the ESA, you avoid the uncertainty in the case law, and you can reduce your common law exposure. Okay? That concludes my presentation, and it is now time for a coffee break. Okay, so let's take about 10 minutes. For those of you who are here, please feel free to enjoy the food and the refreshments. For those of you listening online, hopefully you've got some food and snacks and whatnot in your office, and we'll start up again in about 10 minutes. Thanks very much.
Thank you.